the Malaysian Constitution included and still includes the following foundational stipulations, and in no particular order of importance. They are a declaration of Islam as the official religion of the Federation, but with a guarantee of freedom of religion for all other faiths, the demarcation of civil and Sharia courts, and the continued application of Islamic law for Muslims only on certain matters limited to personal law and custom, a federal form of government, meaning governments at both federal and state governments with central bias of power in the Federation, the formation of a democratically elected bicameral legislature, the preservation of the 9 pre-existing sultanates who would continue to reign as heads of states in the respective states and reconciled at the federal level by the establishment of the position of the Yang di-Pertuan Agong or King of Malaysia, elected rotationally among the 9 sultans for a period of 5 years per term as the head of state at the federal level, the language of Bahasa Melayu as the national language, a constitutional guarantee of fundamental liberties or own Bill of Rights, provisions on citizenship premised on a fusion of jus soli and jus sanguinis, and the creation of the 3 arms of government, namely the executive, the legislature, and the judiciary. These terms saw the creation of a Malayan nation that came to be known now as a democratic monarchy. Most notably, the Federal Constitution contains the 9th schedule that in turn houses 3 lists. The first list enumerates expressly but broadly the exclusive powers of legislation of Federal Parliament. The second list does the same in respect of the exclusive powers of legislation of the state legislatures, while the third list details in the same way mutual powers of legislation. Another thing that was established by the Federal Constitution was the formation of an entirely and completely independent and centralized judicial arm of government. I use the phrase completely and entirely and completely independent because Malaysia adopted the Westminster form of government. What this means is that members of the executive branch of government are not directly elected. They consist of members of the parliament that are mostly elected to its lower house, Dewan Rakyat, and some members who are appointed from the upper house, the Dewan Negara. Thus, like the Westminster system, the executive and federal legislative branches are fused. The Prime Minister is a person elected to the House of Representatives and who is appointed by the Yang di-Pertuan Agong, who in the Yang di-Pertuan Agong's judgment is likely to command the confidence of the majority of the members of that lower house. The rest of the cabinet is then also appointed by the Yang di-Pertuan Agong, but on the binding advice of the Prime Minister. It works the same way at the state level and the respective state governments. They have their own respective state legislatures whose members are elected. One member is then appointed by the Sultan or Governor of a state without a Sultan to be the Chief Minister or Menteri Besar or Premier. The title is the same in principle but changes only in name depending on the state. The Chief Minister or the Menteri Besar or the Premier then appoints his own state cabinet known as the Exco. Insofar as the judiciary is concerned, it exists only at the federal level, while there are branches of the superior and subordinate courts in the various states. They are all coordinated, operated and funded federally. Their powers extend to interpreting, applying and enforcing all federal and state laws, and for the superior courts, this includes the Federal Constitution. And because we adopted the British system in large part, our courts follow the common law system, wherein judicial precedents carry the force of law as opposed to just binding the parties in that case. Further, we apply stare decisis in that precedents from higher courts bind the lower courts. Cases from the Commonwealth, including from the United Kingdom, especially in common law heavy areas such as tort law, are frequently cited and applied. In any case, all the fundamental features that I cited to you just now, I deliberately left out one because it forms the basis of the lecture. And it is that under the terms of our federal constitution, which was negotiated politically to condition the formation of Malaya, it was agreed that the federal constitution would reign supreme. The most foundational clause of the federal constitution from which all other clauses flow is Article 4, Clause 1, which reads, "This Constitution is the supreme law of the Federation, and any law passed after Merdeka Day, which is inconsistent with this Constitution shall, to the extent of the inconsistency, be void." Merdeka Day refers to Independence Day, i.e. 31st August 1957. It is to be noted that in 1963, the Federation of Malaya was renamed to the Federation of Malaysia upon the admission of 3 territories, 2 of them now comprising East Malaysia, that is to say, the 2 Bornean territories of Sabah and Sarawak. The Malaysia Act 1963 was passed to cater for the admission of these territories. The third of these territories was Singapore, who also joined Malaysia in 1963. However, 2 years later, in 1965, Malaysia and Singapore parted ways, and Singapore became its own sovereign nation with its own written constitution from then on. In the formation of Malaysia, there was no fundamental change to the basic features of the federal constitution, especially to Article 4, Clause 1, but just that additional clauses were inserted to cater for additional legislative powers for the Bornean states and institutional protections of their sovereignty. And thus, the main discussion of this topic, Article 4, Clause 1, that enshrines constitutional supremacy, remains existent and alive right from 1957 until this very day.